All right, good afternoon, everyone.
Good afternoon.
All right, I had to browbeat the freshmen. Let's try it again. Good afternoon.
Good afternoon.
Much better, thank you. Blue Devil Nation is honored today to host the Honorable David Lowy, Associate Justice of the Massachusetts Supreme Judicial Court. Justice Lowy is a man of great accomplishments. He has served as a judge not only on the Supreme Judicial Court, but also the District and the Superior Court. He teaches, in addition to presiding over fascinating cases, currently teaching at Boston University Law School. Without further ado, because it's very tempting to read his full resume, I'm going to turn the podium over to Justice Lowy. I know you're going to give him your attention. I know you're going to give him your respect. And more importantly, you're going to give him that enthusiastic welcome that Leominster High School is known for. Ladies and gentlemen, may I present the Honorable David Lowy.
So I heard the word enthusiasm. Enthusiasm comes from the Greek, the God within. It happens to be my favorite word in the English language. Matter of fact, Emerson said nothing great has ever been accomplished without enthusiasm. I am thrilled to have the opportunity to spend time with you this morning. And I want to make sure that we leave plenty of time for questions. So what time should I make sure that we leave enough time?
How about 14 minutes?
So what time?
I'll give you the signal.
Give me
I
the-
will.
All right, great.
Hold the hook.
All right, thank you. So I just said a quick hello to the history class, and I mentioned to them, I didn't tell Mr. Lafayette this until I got here today. I didn't want you to retract this wonderful offer to come speak to you, but my dad graduated from Fitchburg High School, and I know, and I've been to many of Fitchburg, Leominster football. But how lucky are you to be taking a class where you're learning about the law and where you're learning about civics, you're learning about your country. And how lucky are we as citizens of this country to have you doing that? The only way a constitutional republic works, the only chance we have of a constitutional republic functioning is if we have an engaged, educated electorate. Otherwise, democracy doesn't work. So each of you in those seats, I want to start off by saying thank you. Thank you very much for being interested in laws that allow you to get up every morning in this country and to be able to breathe free. I want to thank you for caring about how we got here and what it took for those who came before us to allow us to be able to enjoy the liberty, the freedom that we all enjoy. This is Constitution Day, and I certainly want to talk about the importance of our Constitution. It's important to start out, though, by recognizing that we don't live in a perfect union, and we never have. We formed a government so that we could have a more perfect union, but every day we need to struggle to strive to be a more perfect union. And there's no place better to talk about, and no time better to talk about us not being a perfect union than on the Constitution. And perhaps the most stark example I could give about the work of liberty is not done, is never done, is to think about our founders with all of their accomplishments. They wrote in the Constitution that black people who were enslaved in most of the country were 3/5 of a human being. That is the appalling truth that we need to face. And every day we as a country, need to do better. We're really lucky that we live in a country where we have the two twin pillars of our basic liberties. What does let us get up and enjoy our freedom, the right to vote and the right to trial by jury. We're lucky that we are a place where for centuries people have wanted to come and to enjoy what we're able to enjoy every day. But we're never going to be able to live out the true promise of the Declaration of Independence and our Constitution without recognizing the realities of our birth and the realities of the challenges that we still face as a community, a commonwealth, and as a country. So I thank Mr. Lafayette for inviting me here today. And I thank you very much for having me. I can't help but take a moment and think about the name Lafayette and what it means for our country. The Marquis de Lafayette, General Lafayette, came over from France as a very young man and was a general during the American Revolution. And without the support of Lafayette financially and France, who knows when, if ever, we would have ever recognized our liberty. As a matter of fact, the name Lafayette is so important in American history that in World War I, during a celebration at Lafayette's tomb in France, Colonel of the Army said, centuries later, Lafayette, we have returned. And your teacher went down to Washington, D.C. to learn so that he could teach better at the United States Supreme Court. So there's no more important job than being a teacher. When you're a teacher, you never know where your influence ends. You can never know where your influence ends. You never know what spark some teacher may have elicited in a student in what seems like a random moment of class sometimes. So let's talk about our Constitution and what it means to live under a Constitution. The Constitutional Convention, the process began in 1787, and when I talk about history, I always talk about how history isn't something that happened to the folks that were involved. They were living real lives at that very moment. For those people, history was current events. And the founding of our Constitution was built on what has become the genius of our system, which is the ability to compromise. Some of you undoubtedly are thinking to yourselves, well, that's not what I see when I turn on CNN or MSNBC or Fox. I don't see a lot of compromise. If the genius of America's compromise, we, some might say, have lost our way. And so we need to recognize that for our Constitution to work, we need to have a system of government. And to have our system of government work, we need an inspired electorate who's interested in democratic governance, who recognizes that in order for us to be able to solve our problems, we need to listen with our ears and not with our mouth, and listen to people who we disagree with. We can't all retreat into our own sort of echo chambers and just hang out with people with whom we agree and sort of demonize people with whom we disagree based on our own assumptions. If we're going to be able to thrive as a nation, we need to understand those with whom we disagree. And we have a First Amendment. When we talk about the Constitution, after the Constitution was ratified, we had the Bill of Rights. The Bill of Rights are the first 10 amendments to the United States Constitution. And number one on the list is the First Amendment, which in addition to freedom of speech, includes freedom of assembly, critically important, and freedom of religion. But what freedom of speech provides in this country is the right to be wrong. You have a constitutional right where there's state action involved to have your say. And if we're all not listening to folks who we disagree, how are we ever going to find common ground? Now, Article 3 of the Constitution is the judiciary. And I want to take a couple of minutes to talk about the importance of an independent judiciary and what that means. I didn't run for election. I was nominated by governors for the various courts that I've sat on and confirmed by what's called the Executive Council. Federal judges do not run for election. The point is to be insulated from the politics of the moment, so that not only is the majority view protected, but minority views are protected. People who might disagree with most people. That there's a process for them to be heard. And if you think about, for a moment, the Bill of Rights, whether it's the Fourth Amendment right against search and seizure without a warrant, absent exceptions to the warrant requirement, whether it's the Fifth Amendment privilege against self-incrimination, whether it's the Sixth Amendment right to public trial or right to counsel, whether it's the Second Amendment, the right to bear arms, or the right to a trial by jury. Whatever those constitutional rights are, if we put them up on the ballot tomorrow for an election, many, if not most of those, would lose. Most of those rights in the Bill of Rights would lose. So when we think about the Constitution and an independent judiciary, we need to recognize that we need to protect the rights of distinct and insular minorities. We need to protect the ability to participate in democratic governance by those who have been dispossessed before, and make sure that every vote counts. But the whole concept that you will perhaps touch on in this class of what's called judicial review is an inherently anti-democratic concept. And right now, I'm going to discuss with you something that's incredibly complicated, incredibly important, and if you care about your country and your Constitution, critical for you to understand. Judicial review is the ability of a court to look, for instance, at a statute passed by a legislature, signed by a governor or by a president, and to say that that provision is unconstitutional and that it can't abide. Or to say that, no, we interpret this statute in a particular way as we look at it. This whole concept of judicial review is anti-democratic in the sense that a legislature, a Congress, can pass a law and the United States Supreme Court can say, no, that law violates the right to vote, which is essential for us to be able to recognize and live with the liberty that we all are entitled to under our Constitution. So think about it. Congress passes a statute and the United States Supreme Court says, no, that's unconstitutional, and that cannot abide. So when you think about that enormous power of judicial review, one has to think about, and this is really complex and interesting, how does the judge decide? How does the United States Supreme Court decide that this statute that is not going to allow abortion in certain circumstances is unconstitutional? Or how is it the United States Supreme Court is going to say, no, these statutes that have an analysis of whether or not there's good cause for somebody to have a firearm is unconstitutional? How does the court decide? And my court, the Supreme Judicial Court, before the United States Supreme Court said that there was equality in marriage and the right to marriage for people of the same sex. How does the United States Supreme Court decide whether that's constitutional? What's the source? Isn't that important to think about? If a court is going to say, no, what you've done is unconstitutional, isn't it important for us to know what that source is? Well, it's a very complicated question. And we do know one thing. It can never be, ever be, the own personal views of the judge. Why should one judge's view of abortion be more important than that of a whole country, or of whether or not there's a right to be around? That can't be. So when you read the Constitution and you look it up, guess what? When the Constitution was ratified in 1789, there was no such thing as cell phones and cell location towers, cell site location information. When you go out and you're walking around with your phone, you all know that you're being tracked every minute, right? And that information is admitted in criminal trials. And when I was a Superior Court judge in the last, I'd say, 5-6 murder trials I had, there was cell site information tracking the defendant, and then the police would go out doing darn good police work, and get surveillance information and actually paint a picture in the courtroom of what was happening. Well, when do you need a warrant for that? When do you not need a warrant? Well, think about it. When they drafted the Constitution, there was nothing in there about cell site location information in 1789. The concept would have been incredible if you had mentioned that to James Madison. Completely unimaginable. There's nothing in the Constitution that says abortion. When Roe versus Wade came down, there was an interpretation of the Constitution that from the Bill of Rights, a penumbra emanated that meant that there was a right to privacy that under certain circumstances said that there was a right to an abortion. The Constitution doesn't say death penalty. How do you take these provisions? They're open-ended provisions. They don't provide the answer. They're open-ended provisions of the text. And somehow judges have to infuse into those open-ended provisions meaning to interpret the Constitution. There has to be some source for what we might refer to as normative values. And that source can never be the judge's own personal views. If it is, then we have no faith in judicial review, right? And where's judicial review come from? The judiciary has no sword, has no purse, has no shield. Judicial review and an independent judiciary depends at its core on people's belief in it. And how are people going to believe in it or not believe in it if they don't understand it? So, moral philosophers, I couldn't believe, I looked over and here we have David Hume from the Scottish Enlightenment, who so influenced the American revolutionary, so influenced the Declaration of Independence. If we don't understand these things, how are we going to be a good citizen? And that's why I started by thanking you with everything I have for taking this class, for caring about being an informed citizen. We're all in trouble if we don't. I'll just tell you, education in this country is in trouble. We have people who are not, despite the best efforts of teachers and students, we have folks coming to school and not learning and not understanding our Constitution and our history. So I'll check with Mr. Lafayette in a minute how much time I have left, but I think I should at least answer the question I posed, which is, what's the source of those open-ended provisions that the court looks at in order to decide whether or not a statute is unconstitutional, whether or not there is a liberty interest in it. Whether or not in these circumstances a criminal defendant's Fifth Amendment privilege against self-incrimination has or hasn't been violated. Are they in custody? Are they not in custody? All things that you'll learn about. There's no Fifth Amendment privilege if you're not in custody, for instance. What's custody mean? Well, take out the Constitution, look it up. It isn't in there. The word custody is not in there. We're interpreting the provisions. And when we look for a source of that, what we find is debate. What's often referred to is a philosophical discussion, what the philosophers call a dialectical discussion about what the source might be. Should it be some sort of evolving consensus? We're looking to where we want to be, what Lincoln called the better angels of our nature. Is it based on some sort of natural law, whatever that might be? And is it the founders' view of the Constitution that matters exclusively? Is it a text-bound analysis? Are we all prisoners of what they thought in 1789? Is that the prism through which we look at the Constitution? Or is the Constitution a living, organic document that should be interpreted based on the time in which we live? Which one is it? My view is it's the latter. It's the second. But it has to be a text-bound interpretation. It just can't be whatever judges might think when they get up in the morning that the provisions. So why don't you get involved in the debate? Why don't you become interested in the law? Why don't you make a contribution to liberty and equality of opportunity? Be an engaged citizen. Help heal the world. Help make the world a better place. You've already started by signing up for this class. So, is this a good time to take questions?
Well, Your Honor, I know that you had mentioned the discussion of civility in society.
How much time do I have to dwell on that?
If you can distill that into 5, that would be great, because I know you want to do questions and answers, and these young men and women have them for you, but I think the issue of civility is very germane.
Okay, so let me just remind you of what I've already talked about as it relates. Civility is the ability to talk to people with whom you disagree, to have a productive discussion, and to talk to people who you disagree with by engaging in what a great TED Talk, Teresa Vidal said, staying in the room and disagreeing with people to their faces and not behind their back. President Kennedy, in his inaugural address, said, civility is not a sign of weakness. So being civil and patient when you listen to people with whom you disagree is essential to a democracy. But where did I start? Didn't I say that for all we can say about the greatness of this country, there is a stain that needs to be recognized. Here we are, a country born based on liberty and equality of opportunity, and yet tens of thousands of black people were enslaved at the beginning and even before our country's birth. And the truth is that civility sometimes was used in our history as a weapon. We saw that in the civil rights movement in the early 1960s in the South. We saw civility used as a weapon to try and, quote, maintain social order or make sure that some people didn't have the same. So when we talk about civility, I'm not talking about tolerance of Nazis or white supremacists or their abhorrent views. But I think it's really important to recognize and to understand and appreciate that the overwhelming majority of people with whom you disagree are not Nazis and white supremacists. And incorrectly labeling them so is not debate, it's disgusting. And if we're going to be able to have civility, which again means talking about really hard subjects with people with whom we really disagree, then we need to not make certain assumptions about them and have a conversation. And the most important place to have that conversation respectfully and listening to others and making sure that people who disagree don't become just part of what I refer to as that echo chamber where that person is afraid to share his or her own view, which is going to perhaps bring energy and thought to a discussion. Because guess what? You don't learn much when you're talking, and you don't learn much when you sit around with a bunch of folks you agree with, chatting about what you all agree with. Good luck learning in that situation. So in order to be able to engage in civility, it takes courage. It takes strength. Sometimes I feel that when I'm having a discussion with somebody, I actually have to bite my lip so I don't talk in the midst of them saying something that is bothering me so much. I actually bite my lips because you need to hear them out. And you know what? Maybe if you engage in civility, maybe you'll change somebody else's mind. Maybe you'll change your own. But if nothing else, you'll engage in a discussion that's ultimately going to foster the type of informed citizenship that we need. So let's think about what I said a minute ago. There's no place more important for this discussion to take place. There's no more important place for civility than in an education environment. Right now, the First Amendment is under assault on college campuses. Here you are in a class where discussion is critically important. And that ability, when you are in a situation where you are learning to engage in civility and listen with an open mind to what those who disagree with you say, there's no place more important than that. We can't have, and to paraphrase Thomas Jefferson, you can't have ignorance and liberty and freedom at the same time. There is no way that you can have ignorance and have freedom. There's no way. you can't reconcile ignorance with freedom. So when you're in class, listen with intensity to those with whom you agree and, more importantly, with those whom you disagree. And then take a reflective moment to think about how that impacts your own thought. The response might be, okay, I thought about it, doesn't change my mind at all. That's okay. You engage in civility, you listen. And if nothing else, you know what the other side's view is in order to be able to take a different view. So I think that's about 5 minutes. I really want to make sure there's time for questions. Thank you so much for inviting me here. It's really a privilege for me to be able to come into a high school classroom. I love it when I get invited into a high school classroom. I look out and I see nothing but hope. And how lucky are you that you get to take a class where you're learning about the law in the country in which you live. Thank you all very much.
Mr. Justice Lowy, I'm going to take the opportunity to say that they have, in keeping with your comments, and you certainly did not compare notes, they have a great opportunity to listen to an episode dealing with the missing ingredient in American society, paraphrasing, on a podcast that you may or may not have heard of, Law with Mr. Lafayette. So if you have the opportunity, ladies and gentlemen, that's going to be an assignment for tomorrow, but remember the warning. Do not operate a motor vehicle or any heavy machinery while listening to said podcast. Am I covered legally, Your Honor?
You're good.
All right, excellent. We have Megan Doobie, who is going to be reading questions that students have formulated. And Megan, it's yours.
Hey, Megan.
Oh,
Nice to meet you.
okay, so, Your Honor, you talked a little bit about how we have such a great opportunity here in taking this class. And I know for me personally, it's definitely inspired me to pursue a career in this subject, and I hope for a lot of the other students. So my question for you would be, did you have a similar situation that inspired you to pursue your career?
So I think that there wasn't one episode, but a lot of it had to do with my uncle was a law professor at Suffolk Law School. He had actually represented the Boston Strangler in the 1960s. And I remember being young and saying something to him along these lines. Maybe I was 8, 9 years old. I said something along the lines of, aren't you afraid? Aren't you afraid for your family? Why do you want to represent somebody who goes around strangling and killing and assaulting women? And I wish I had been savvy enough to write down what he said so I could tell you exactly what he said. But through the years, if I look back at it, it was something along these lines, which is that the opportunity to be a lawyer is an opportunity, he didn't use these words, I'm sure I wouldn't have understood them, to represent the dispossessed, for those who have the least voice in our society. But you don't have to do that. You can also represent the biggest corporations, whatever it might be. But de Tocqueville, in his 1832 book on America, came over from France, masterful book, talked about lawyers being the aristocracy of America. I hope that's not true. I hope we have no aristocracy in America, but that's what he said. And so he was talking to me about that it was an honor to be able to represent this man charged with these horrid, disgusting crimes. And I was still having a hard time understanding that, quite frankly. I was still having a hard time getting my head wrapped around that. And then he said something along the lines of, when you represent the least among us, and John Adams did that after the Boston Massacre trial. He represented the soldiers in the Boston Massacre trial in the 1760s. You protect everybody. You protect everybody's life. I was a criminal defense lawyer, as a prosecutor, worked at a big firm, had all sorts of jobs. But when you are a criminal defense attorney and you represent that person, the Constitution provides for it, and you recognize everybody's freedom and help keep the government honest. So how that discussion exactly happened, I don't know. But when I confronted him and he told me the why, it inspired me, and I'll never forget it.
All right, so that is a good segue into the next question. For those of us who are interested in law, what advice would you give?
You want to go? Those people who want to go to law school.
Sorry?
For people who want to go to law school.
Yeah, for people who want to go into law and go to law school.
Okay. All right. Well, I need to give you an honest answer to that. The three most important things about getting into law school are working really hard, and working really hard. It's being at the kitchen table in your AP classes in high school at 11 at night. It's not being on your phone. It's being hungry. It's wanting. I've been teaching law school for 32 years. And it's hard to get into law school. It's hard to do well in law school. It's hard to do well enough in college to get into law school. So if you want to be a lawyer, love school, be hungry, and want it. That's what you got to do. You got to look yourself in the mirror and decide, do I want to pay the price, or do I want to watch another episode of whatever show streaming that you really want? You got to ask yourself that question.
All right, and then you talked about how you teach at a law school and you have taught at several law schools in the past. Why do you want to teach law after being in the practice for so long?
I don't think I could ever give up teaching until I can't stand in front of the class, and then I'll probably sit. Like I said, I've been 3 decades now teaching, and it's the opportunity to try to do my best to inspire people to be great lawyers and to be great citizens and to give back to the country. You know, Tennyson said, "To whom much is given, much is expected." My father escaped the Holocaust. He came here when he was 4 years old. Grew up in Fitchburg, but he worked his way through dental school, working in the paper mills in Fitchburg. But I, on the other hand, I was born on third base, and I didn't hit a triple. I was born on third base. I had every opportunity given to me, and shame on me if I hadn't done anything with it. And so teaching law school is a way to, I think, give back the privilege of having been born on third base.
All right, and then the next question. So obviously, you are an associate justice on the Massachusetts Supreme Judicial Court. Do you ever feel overwhelmed with the responsibility of being in such a high position?
So I think very few attributes are more important than humility. And I say to myself every day, with every part of the job and every decision, it's not about me. It's never about me. And that has to be the recurring theme of my professional life on the state Supreme Court. It's never about me. And so, since it's never about me, I don't believe that I have the prerogative of being intimidated by the responsibility that I swore to fulfill. That's just not a luxury that I believe I have. But humility being important, when the seven of us sit around the table and talk about the law, that concept of civility that I was talking about, it's really important. It's important that we not interrupt each other, that we listen to each other with intensity, and with an open mind. That's and a reverence for the law and for the Constitution. So since I'm always thinking in terms of it's never about me, I don't run into that issue.
Okay. And then, so before you became an associate on the Supreme Judicial Court, we know that you were a law clerk. Can you tell us a little bit about that job?
Yeah, so being a law clerk is the best way to start after law school. You know, I have 3 law clerks. The law clerks are hired from the best students in the country, and they're brilliant. One of my former law clerks is now a fellow at the United States Supreme Court, actually, and it's just it's a great way to start your career. The judge I clerked for in federal court is now 88 years old. Former law clerk Zoom with him every month. We have a different book, poetry, or short story, or movie that we watch every month or read, and then we have a discussion about it with him. He sits in a big armchair at 88, and he's still incredibly important in my life, and my law clerks are incredibly important in my life as well. I always say the worst day of the year is the year the law clerks leave. The best day of the year is when the new law clerks come in. It's the best way to start a legal career because you're starting at the apex, at the top of litigation, and you can learn so much doing it. But again, it's something that if that's something you want to do, and you can't in any way be afraid of hard work.
Oh, great. And then, what is your favorite and the least favorite part about being an associate justice?
Well, I really like going out and speaking to groups, I have to tell you. And nothing's better than speaking to young people because it's now in your lap. My generation hasn't done a very good job. You know, in the Civil War, there was one soldier when the North was charging would hold the flag, our nation's standard, and if that person fell, shot, killed, somebody else would pick up the flag and hold the flag without a weapon. And I feel like in many ways my generation has lost its grip on our standard, and it falls to you now to pick it up. And there's so many issues. So for me, the opportunity to talk to people who are going to be future leaders and future citizens involved in democratic governance is one of the best parts of our job. My favorite part of the job, though, is what we call consultation. And that's once a month when we've circulated all our draft opinions to the other justices. And then we have a discussion about each opinion. And ultimately, there's a vote. And is somebody going to write a dissent or a concurrence? Is somebody going to make a suggestion about how to improve the opinion? Or they don't like part of the opinion? Will the author include it? Or will that person not join the majority? Will it switch the majority? that discussion is so fascinating, so engaging. I love that. It's not very exciting, but my least favorite part of the job is there's an appellate, intermediate appellate court in Massachusetts. You have the trial court, you have the appeals court, and our court's the state Supreme Court, the SJC. And we have to look at when there's a request for further appellate review after the appeals court's made a decision. We need to review those cases and decide whether to take it. And that's a long, tedious Saturday to Sunday going over all those opinions, deciding whether to grant further appellate review. That's a very small source of our cases. Very few of our cases are further appellate review from the appeals court. The appeals court is the last word on 98+% of cases in this Commonwealth.
So that actually brings us into a good next question about how many cases does the Massachusetts Supreme Judicial Court accept and hear per year?
All right, so roughly, there's all different kinds of cases. We have sometimes staff attorneys will draft an opinion of what we call a non-complex case. So it's counting non-complex cases, the amount of published cases is about 200. Also, as Associate Justice of the SJC, we take turns being single justice where emergencies issues or issues where there's no other source of relief can go before the single justice. Those cases are ultimately reviewed by the SJC. The 200 is a very interesting mix. We have to take the first-degree murder cases by statute. So every first-degree murder conviction is reviewed. And when I was a Superior Court judge, I had more murder trials than any other type of trials. But that's not a big chunk of our cases. That's certainly under 20%, and in pure numbers, really much more than under 20%. Many of our cases come from what's called direct appellate review. The case will be on appeal, and the lawyers will ask for direct appellate review, which means to come directly to the SJC without going to the appeals court. And our staff attorneys review every case filed in the appeals court to see if we're going to take the case on our own initiative. And we have a hearing list committee that I chair that reviews whether or not to take these cases. But there's very few slots. So which cases we take is really important.
All right. So when you first graduated from law school, did you ever imagine that you would be doing something like this, speaking to various schools across the state?
Not a chance. I just went to work my first day clerking, afraid that the judge was going to talk to me because I was so afraid of him. Never mind that I would be doing that. He'd come into the law clerk's office and want to talk about a various issue, and I would just shake it. So no, not a chance.
What would you say your greatest accomplishment in your, honestly, your entire career would be?
I think that one of the things I am most proud of and really enjoyed was during the trial. So when you're on the Supreme Court, you don't do jury trials. Those take place in the trial court. We review the cases to see whether or not we agree with what has happened or disagree with what's happened. But when I was a Superior Court judge for 15 years, I had many times jury trials, not always jury trials. And a jury trial has been referred to, think about this, the majesty of this. A jury trial has been referred to as a ceremony, a civic ceremony. Government is manifesting. They manifest the power of the citizens. And ultimately, in a jury trial, the jury returns a verdict. And the verdict comes from the Latin word to speak the truth. And the thing that I enjoyed the most, and maybe feel I did okay at, was inspiring juries to be the best they could be, to decide the case not based on sympathy or emotion, not based on their own personal idiosyncrasies or biases, but based on the evidence and facts, if they find facts from all the evidence, and the law the judge teaches. So I think that, and I miss it a lot. I think dealing with juries, I was amazed time and time again about how amazing judges are. I had that, the only case that you may have heard of where the Danvers school teacher was killed by a student from class. That was a case tried in front of me for months. And that jury was, they were unbelievable doing the best they could do. And people come to jury duty with all different attitudes about the juries. Most people aren't really too keen on serving, take the time out of their busy lives to serve as jurors. And one day I was at a friend's house, a friend of my wife, and we were in a pool, and she said to me, you know, I have jury duty tomorrow up in Lawrence. Do you have any suggestions how I can get out of jury duty? And I said, well, I don't know. How did those 18, 19, 20-year-old men who stormed the beach at Normandy, most of them giving the last full measure of devotion that this nation might live, feel about that when they stormed that beach at Normandy so that we would have a right to trial by jury? Jury duty is a privilege of citizenship and also a responsibility. That's our bell, right?
It is.
All right.
Excuse me. If Mr. Doherty's, thank you. If you can please remain seated just for a moment. Dr. Romano, before Dr. Romano takes the podium, ladies and gentlemen, I just want to make a quick observation. We as educators rarely have the opportunity to hear the names of de Tocqueville, of John Adams, of Hume, of Jefferson, Lincoln, and Tennyson spoken in a single sitting. You may or may not appreciate what you have heard today. I think that Dr. Romano will echo those comments, and not just presented, not just given to you today, but given to you with such genuine humility. Ladies and gentlemen, our principal, Dr. Josh Romano. Dr. Romano.
Mr. Lafayette, you did raise the bar for my comment. I was going to thank you for coming in, despite your connections to Fitchburg, and just be grateful that you weren't there for the shellacking that we gave Fitchburg High School a couple of weeks ago. But now I do have to raise the bar, and I do appreciate what you said. I was a history teacher myself. I'm a veteran, and the comments that you made, I think they speak a lot to what we hope for this generation and what they might be able to take forward with our government and with our society, and build back to that civility that I think we all aspire to. So we appreciate very much that you were here. I hope that I can get some pictures for you, because I started an Instagram, not Instacart. Students told me to start an Instagram, and I hope we can get a few pictures of you. And we very much appreciate you coming out, the amazing comments that you made for us today. Mr. Lafayette, thank you for arranging this.
Of course, thank you, Dr. Romano.
This is fantastic.
Ladies.